Let's start the meeting. Stand up, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. I'll turn my cell phone off, so I'm doing it for myself. First order of business is approve the minutes for January 13th. Anybody have any additions or changes to the minutes?
No, I had a couple of minor changes that I'll just give to our secretary that,
Yeah.
but otherwise it's fine.
Okay, great.
I make a motion to accept them as corrected.
Yeah.
I second it. All in favor? Aye. Make a motion, motion. Minutes of February 10th. Anybody have any changes or corrections?
Same thing.
Same thing? We'll do- Okay. Can I get a motion?
Motion, I give the motion.
Motion. You second it? All in favor?
Aye.
Oh, yeah, good. Okay. First order of business is, let's see. Alex Campbell, 4 Cliffside Court. I guess, Mr. Watson, are you handling that? This is for applicant seeks a relief from requirement to provide a front yard setback of 50 feet from the center line of the traveled way in front of the subject property. The partially constructed residential structure has a setback of 32.2 feet from the center line of the existing traveled way and 36.2 feet from the center line of the right-of-way. Applicant therefore seeks a variance of 12.8 feet. I understand that the house has already been built or in the process of being built, and then they found out that they were too close to the street?
Yes, that's exactly right.
Okay.
Glenn and Watson from Beatty and Watson with Alex Campbell, your appellant. As the public notice stated, we're seeking relief for the front yard setback. We've submitted an application with, at the end of it, with reasons stating our belief that should be granted the relief he needs. And I'm going to be very blunt and very frank. He was the victim, in my opinion, he was the victim of just shoddy contracting work who were trying to cut corners and didn't do what needed to be done. We've had a situation with the septic system, which is not part of this thing. It's been in the right place and everything. We had to completely remove the fill and put the fill back in because it was not the specification. I'll let Mr. Campbell tell you a couple of the other horror stories. The other one that I know of is that some of the walls when this thing were put up and covered over before proper inspections were made, even though he was told, according to what he's told me, he was told that those inspections had been made. The building went up without it being laid out properly. And I don't know if you can't respect a setback line without staking the line. And it wasn't discovered, as stated in the papers that we put forth. It wasn't discovered until afterward. In fact, well, it wasn't discovered until after we surveyed it and laid it out, and we didn't lay it out. That's putting the stakes in to show you where to put the house. We didn't do that. Nobody did that, except the contractor decided to do that himself and consequently made assumptions that he shouldn't do and put it in the wrong place. So we're trying to redeem everything we can out of this thing. The building is virtually done. The septic system has been repaired, really undone and redone. And if you go down there today, you'll see a tremendous improvement in the site. So we're seeking relief so he doesn't have to tear this place down. It's just that simple.
I did a site inspection. I looked at it, and I guess pretty much it's mostly the carport that would be in the, with the variance more than the house.
The carport, it's the carport that's encroaching into the front setback.
Correct.
Unfortunately, the carport, if you took a close look, I don't know if you did
Yeah.
or not, but it's wired. The electricity comes into the front of the carport. And
Right. I saw that.
there's all kinds of stuff like that that's going on there.
Right.
And the repositioning, not to tell a little more of our tale of woe here, the repositioning caused the driveway not to work right. It's been one repair that this man has had to suffer after another. You did receive a letter from his attorney with regard to the legal aspects of those reasons and her reasoning that we have met the burden. The reasons that I put forth in the application are a little less legalese and a little more towards
Understand.
asking you to understand this man's position. He's the owner, there's a lot of talk about the owner's responsibility. Even if his builder makes a mistake, it's still the owner's responsibility. And I guess that's the general tenor of that fifth non-dispositive reason. But he did go out and he did hire a licensed contractor. He wasn't doing this with his buddies on the weekend and that kind of stuff. So he's already paid a significant financial toll on this to remedy it, and he's facing another fight with his contractor. So we're hoping that the board will see it we'll see some leniency in this thing and grant the variance. I understand there are 2 letters from neighbors who are in support of that application. I don't know if there are more here or not.
Right. Okay. Wait a second.
So I don't have an awful lot to. We're faced with a situation that
Right.
our only real option otherwise would be to tear this thing down and move it back, because the carport is essential to this building. There's no foundation. It's on a slab, so there's no place for storage.
I understand.
That's my whole-
I
that's
did a
my
site
whole-
inspection, so I understand what you're talking about.
That's my whole story.
Okay. Anybody else here would like to speak about it? I saw some hand raised. No? You got to come up here. Okay, sure, come on up. Don't be afraid. We're not going to bite you. First, you give us your name. Come to the microphone.
Elizabeth Coulomb. I'm at 88 Upland Drive, which is the road that Cliffside comes off of.
Okay.
So just from some of the people I've talked to, I can't speak to everybody. There are several other houses, but our general feeling is that Cliffside is a dead-end street. It's a dead-end street that goes to the top of a mountain. There's no reason that it would ever need to be widened. So having a large variance on either side, we can't foresee that coming into play at any time. And it's not a high-traffic road. There are a very limited number of houses on it, and Upland Drive is no longer a through road. There's very little reason there would be extra traffic going by his house that would be in danger of going into it or troubled by it being too close to the road. And so as neighbors, we don't really see any problem.
All right, so I take it you're in favor.
Yes.
Okay, thank you very much. Anybody else would like to speak? No. Okay. At this point in time, I'd like to go to 5 factors with you, Mr.
Yes.
Okay. Nobody else would like to speak on it. First question, applicant seeks relief from requirement to divide a front yard setback of 50 feet from the center line of the traveled way. Denial of the permit, it's a little small wording here. I don't know who did it, but I can't read it.
It's one of those form fillers that gets smaller as you use up the space.
Right. Give me a rough idea.
Except.
Can you see it?
Except for the house. Except for the
All right, let's
house
see if I
on
can
the
read
parcel
it.
immediately across.
Wait, he's got better
Oh,
eyesight
okay.
than me. Can you read that?
I can read it, but not very well.
Except for the house on the parcel immediately across Cliffside Court, which is approximately 100 feet from the applicant's structure, there are no other houses that will have any significant view of the property.
Okay, I got that. All right, the second one is, what impacts would the variance have on the character of the neighborhood? Well, this is a little big writing, so I could read it.
Okay.
Where similar variances granted to other properties in the neighborhood, the houses would appear closer to the road than the zoning envisions. However, because the land is on a private road in an area of Continental Village where there has historically been less dense development, the house would be spaced relatively far apart, and a smaller setback would be somewhat less noticeable. Second question is, if you didn't get the variance, how else could you build what you want or accomplish your goal? I'll try that again. We're back to the small letters, okay. This is now there is no feasible way for the appellant to accomplish the goal of building the structure as designed. While it would be possible to tear the entire structure down, the house and the carport, and move it 12.8 feet further back from the roadway, and doing so would virtually be impossible for the appellant. What code you seek to vary? Section 175.11B, required front yard setback. How large is the variance you seek? 12.8 feet or 12.9 inches? Which one were you looking for? The answer to the question is have 12.8 feet or 12.9 feet and a half inches.
9.5 inches.
Okay,
They're equivalent.
They're equivalent. You got it. Okay. It just confused me with the two numbers there.
Yeah, well, I work in decimal feet and I convert stuff for you guys.
Okay. Number 4, what impact or effect will the variance have on the current physical and environmental conditions in the area? Because the structure is already in place, granting the variance will not have any direct impact or effect on the current physical and environmental conditions in the neighborhood. Number 5, is the variance requested as a result of self-created hardship? The variance is not a result of self-created hardship. The applicant did all that can be expected of a property owner lacking the knowledge of the zoning building process. He engaged surveyors and engineers to guide him through the approval permitting process. He hired an experienced Putnam County licensed contract manager to build the project according to the approved plan. He authorized a survey and engineering work necessary throughout the project. Unfortunately, the construction manager failed to request a stake-out work, and that would have avoided the problem. And I could see that. I say nobody here spoke against it. There's only one neighbor who spoke in favor of it. I looked at like I said, the site, and I don't see any issue with it as far as it being there and any reason not to grant the variance. Is there any comments or anything from anybody on the board? Anybody else would like to speak to this? No? Okay, at this point in time, I'd like to make a motion to close the public hearing. I'm sorry.
Can we point out?
Can you come up here?
I'm
Okay,
a-
your name.
I'm Maria Nattiello. I'm also a neighbor
Okay.
on Upland Drive. And we have, my husband is here and 2 other neighbors.
Okay.
And we are all in favor of the variance.
All in favor?
All of us here are in favor.
Can't go wrong with that.
All right.
Thank you. Okay, it's the time.
Motion's on the table, I'll second.
All in favor?
Aye.
All right, the motion is closed. Public hearing is closed, I'm sorry. This time, can I get a motion to, on the variance?
I move to approve.
Got a second?
I vote a second.
Okay, second. All in favor? Okay, it's unanimous, it's approved.
Thank you very much.
Thank you. Welcome to the neighborhood. You gotta remember, you got a plow over there getting out of the winter. It's a private street. Okay. Okay. All right, next item on the agenda is Jared Delaval, 117 Round Hill Drive. Applicant seeking a variance to a structure garage larger than 1,000 square feet.
Yeah, so I'm Roland Heitman here on behalf of Jared Delaval.
Are you the contractor? Or?
I'm the contractor.
Okay,
Yep.
go ahead.
Well, so we've applied for a variance for for the 1,000 square foot size limit. We proposed a structure of, I think, 1612
Right.
square feet, and tried to make it very inconspicuous. It's kind of buried into the hillside, and we even presented a representation
Yes, you did.
of that to show how inconspicuous it is.
This photo here.
Yep, exactly.
That's what it's going to look like, yeah.
Yeah, so it's kind of hidden in the hillside. It's really not
Yeah.
seen by any of the neighbors. And I know that Jared reached out to all of his consecutive neighbors and presented it. And I'm sure that it was sent out here from a public hearing standpoint as well. So, and he had all, either, certainly no objections and positive feedback otherwise, so.
All right. No, I did a site inspection, and it's a beautiful house, that's for sure.
Yeah, thank
Really
you.
nice. And
We
the
built
garage-
it too.
And the garage looks like it we'll go with.
And it
go
was
with the house.
staked, it was staked, I think Beatty and
Yeah,
Watson
Mr.
did stake
Watson.
it there. yeah.
They did stake it. Yeah, well, it's a good thing to
Yeah.
stake it before you build.
Well, yeah, exactly, from what we've seen on the last one, so you could see where it was then, yeah.
Right, right. Okay, is anybody in the audience would like to speak to this appeal? All right, make note for the secretary, there's nobody here to speak to it. Okay, the same thing, at this time, I'd like to go over the 5 factors. We use these questions to try and determine the validity of the variance.
I have my copy here, so if
That's
you-
okay, I'll ask you
can
a question. I got your answers here.
Yeah.
What possible detriment would the variance have on nearby properties?
I
Virtually
get-
none.
Yeah.
Only structure you can see is my house. I also own the neighboring lot, which is the only one you can see, from the garage, okay? I say I did a site survey, and I agree with that. 1B, what impact would the variance have on the character of the neighborhood? Virtually none. The garage is buried into the hillside to minimize visibility. I agree with that. Number 2, if you didn't get the variance, how else could you build what you want to accomplish your goal? We could build 2 structures under 1,000 square feet to get the same usable space, but that isn't what we want to do. Well, 2 structures would only make it more obvious than
Yeah,
one
yeah.
structure underground. I have to agree with that. What is the code requirement you seek to vary? Garage is under 1,000 square feet. That's section, I don't have it, but you'll have it. Attorney will have a section for the more than 1,000 square feet garage.
Yeah, it's 175-10D5.
Okay,
Attached or detached
garage.
structures garages can't exceed 1,000 square feet.
Okay, good. Let's see. What impact or effect the variance will have to the current physical and environmental conditions of the area? It's a small area around the structure, and we want to minimize disturbance. There may be rock hammering to properly set the garage. No paving of driveway, no drainage patterns will be affected. No emissions of extra traffic. It's just used to store cars at my residence. There's only a few homes up there. I think there's only 3 or 4 homes up there.
There's
by the
3
number.
homes on the entire road.
On the
yeah.
entire street. That's a private road, too.
Yes, it is,
Correct,
yeah.
okay, fine. Number 5, is the variance requested a result of self-created hardship? No, it's not a self-created hardship, it's just that you want to build 1 garage instead of 2.
Exactly.
Right. Anybody board have any questions?
Yeah, I have a couple questions.
Sure.
The other lot that you were talking about, what are your plans for that? Do you have plans to build
Right
on?
now, there's no plans, so, I mean, again, I'm representing the owner. He bought it for kind of a family, he has children in the teens, and he's envisioning a family compound of sorts over the next 15, 20 years. No current plans to do any development on the next lot.
And will the garage have plumbing or heating in it?
We'll have heating, but no plumbing. No active plumbing.
Anybody have any other questions?
And just,
Sure.
why would you have the heating in the garage?
Why would you?
Why are you putting heating in the garage?
Because he likes to collect cars, and the cars are, it's my understanding from him, I'm not a car collector myself, but that he'd like to keep an environment of like 55 degrees and a certain humidity level for maintenance of the cars.
No, I'd say so. It's a beautiful house, beautiful area, and there aren't many homes there, so I don't really see a great effect on the neighborhood.
Okay.
Anybody have any questions? Can I get a motion to,
I make a motion to close the public hearing.
second?
Second.
All in favor?
Aye.
Make a motion for the variance?
I'll vote to approve.
I'll second.
Approve?
Approve.
Approve? I approve.
Okay, thank you
Okay,
very much.
build the
Appreciate it.
garage.
Thank you very much.
You're welcome. Next order of business is Louis Quinn, 21 Ferris Drive. You here? Want to come up to the microphone, Mr. Quinn? You are?
Hi, I'm John Turnquist, JT2 Architects,
Okay.
and I have a couple of things I'd like to show you in reference to the project.
Well, let me go through some things first. Let me explain to you. I see that this was, your building permit was denied under Section 170, 175-23B. That's a non-conforming structure.
Yes,
Okay. Do you understand why it was denied to you?
we do.
Okay. What happens is this is a application hearing. What I mean by that is we have to see if we have all the information that we need in order to make, in order to go to a public hearing. If, once we get all the information we need, the board will vote on that, we'll approve the application, and then we'll set a public hearing. Now, what happens at that point in time is the neighbors are notified by mail and so on and so forth. An advertisement is put in a newspaper of a public hearing. So anybody, any of the neighbors, or anybody in the town who has any interest or any concerns will be able to come to the meeting and voice their concerns. This way you don't start building and somebody has a concern, then we got a bigger problem there.
Sure.
You understand?
Yes.
So I understand you want to put a second story on it.
We do.
Okay, let me tell you what you need, because you don't have everything here. So you're not going to be, do you have a piece of paper? I'll write down what you need. You
I
got a-
do.
Here, I'll give you a piece of paper.
Yeah.
You got a piece of paper? Because you need a number of things.
Okay. Just so you're familiar with
You can save that for the public hearing.
it. Yeah.
Okay. Because this way, everybody will have a chance to look at it. Here, take this piece of paper. You got a pen? Okay. Great. You're going to need a current survey. You don't have a survey here, okay?
Okay.
And that current survey is going to have to be stamped by a surveyor, and it's going to have to show where the existing structure is. The reason for that is we're going to have to know what the sidelines is, you know, the front yard setback, and so on and so forth. Because you're going to, you're under what comes under pre-existing non-conforming, and you're looking to increase more than 25%. So you're going to have to come before the board. You may need a variance and so on and so forth. But there's no way of us determining that until we see a survey.
We did get it.
Okay,
Yes.
so I got to do that.
We did.
Number two, you're going to need architectural plans. Now, I see.
I don't mean to interrupt, but was the survey submitted with the application?
When we submitted for the building permit, we did submit the survey, I
There's
believe.
no survey here.
I'll make you another copy. Yeah, no problem.
Okay, good, that's great. It has to be a stamped survey.
No problem.
Okay, we don't have it.
We have a new one.
Yeah,
Okay.
only thing I have here from the building department is, I guess he sent you a denial, and also sent you an application to file an appeal.
Yes.
Okay. But here, this is it. This is what I'm saying.
Okay.
here, Okay? I have nothing.
Okay.
Okay. So, we're going to have that. And you're going to, the architectural plans, they're going to have to be stamped.
Yes.
Okay, they're not stamped. The ones I
Okay.
have here are not stamped. They're going to be stamped. And you're going to have to show me the front of the house, side of the house, and the rear of the house. The reason for that is have to know the height and division in the front and division in the back. This way, when the neighbors come, if they come at all, they'll be able to see what you're planning to do. Because you're planning to make a 100% increase on your building.
That's correct.
Correct. So, I'm not saying it's not a problem. All I'm just trying to say is it's only fair that the neighbors be able to get a chance to see that. You understand that?
Yep.
Okay.
Yes.
And you're going to need a worksheet. What I mean by a worksheet is, first you're going to need the original CO. Okay? There's no CO in here.
Yeah, I don't know if there is a CO for that. No
You
CO.
don't
Well-
need either.
Try and get a CO from the building department. I know sometimes it happens, and they'll take a look at it, and they'll give you a CO of the current structure, you know. They'll go by an old building permit or something like that. I'm not sure if it is an old building permit or not, but that's something you have to check.
All right.
You're going to need a copy of the deed, okay? And you're going to need, it's called a worksheet for the 5 factors that you've heard me talking about tonight. You get that from the building department
It's
also.
also on the website.
I'm sorry?
It's on the website also.
All right.
On the website also, and you can get it from there. Okay.
Don't they have that?
So, and then you're going to need names and addresses of your surrounding neighbors. Now, when we get to that point, our secretary will be able to help you with that. You know, she can help you get that. But if you know any of your neighbors or, names and addresses, that would be helpful. It would help her.
They do have the 5 factors.
Are 5 factors here? Hold on, wait a minute. I'll go back. Oh, no, okay, we do have the 5 factors, so you can cross that one off the thing. You don't need the worksheet. The rest you need.
Okay.
Okay? And like I said, so we can't even, we couldn't mark this complete tonight. So next meeting is April 13th, Monday, April 13th, 7:30 at here. And you bring all that with you, okay? At that point,
They have to get it beforehand.
Yeah,
Get it
send
to
it
us
to
beforehand.
our secretary.
We have all of the information, so yes,
You
I'll
know,
provide it for
we
you.
could
Yes.
bring it to the town, and then the secretary can send it to us so that we can look at it. So it's not submitted that night.
all right. Oh, yeah, well, yeah, I agree with what he's saying. He's trying to get it to the secretary, our secretary, before the night of the meeting,
Sure.
okay? Because she sends out a package to us of everything for the meeting, usually like a week before or something like that, So if you can get it to her as soon as possible, okay? She's also in the building department, okay?
No problem.
Secretary, and give it to her. She, in turn, mails a package to us, and we have a week to look at it before the meeting.
Okay.
Okay, we don't want to have to just open it all at the night of the meeting. And thank you
Okay.
for telling me, reminding me of that. So we don't, you understand what I'm saying?
Sure.
Okay, and that's about it. And then at that meeting, if you have everything, we'll be able to vote on it that's complete, and then we'll set up the next month's meeting for your public hearing.
Okay.
Any other questions, gentlemen?
No.
Okay, go ahead. That's it.
Not really. Any questions, but,
No, I don't have to look at it. Save your,
yeah,
for the next time.
is it feasible? I just,
Yeah,
just trying
okay.
to get, yeah.
You want to tell me, go ahead. I'll give you 2 minutes, go ahead.
No, what we're doing is adding on to the existing building. And I just
Okay.
wanted to know what the feasibility of that was.
Right,
And
and you're going to put a second story on.
we're going to put a second story on.
Okay, I got it.
Yes. No change in bedroom count, no change in occupancy, just a better functioning layout of the building.
Sound like a plan to me. Bring all the necessary material to us, and we'll take a look at it.
All right, very good. Okay,
Okay.
we do have it then.
Thank you,
Thank you.
gentlemen. Okay. All right, next is,
The fun part.
continuation of public hearing on Jose Romero on a revocable trust at 529 Route 9D. This is the third public hearing. Since the last,
Recuse myself.
oh yeah, you got to recuse yourself.
I'm going to recuse myself.
Because he's working on the house, so he can't, All right, since the last public hearing last month, I received several communications. One was a letter from Joan Turner. Is she here? Joan Turner, okay. She used to be on the board for years, and she had a letter where she'd like to make a statement regarding the interpretation of building permit issued at Route 9D. We'll get to that in a few minutes, okay? Second thing is, I received a email from Frank Smith. I guess that's your attorney? Oh, yeah, you're there. Okay, Mr. Smith, I'm sorry. Your email says, I got that's today, unfortunately, late in the afternoon, all right? You said that could you kindly confirm receipt or email by phone, we greatly appreciate it. Well, I could tell you now that I did get it, but it was late this afternoon. And it's like about 13 or 14 pages, so I'm not going to be able to read it, okay, but I do have it. Okay. Next communication is from, let's see, I got that one. Dr. Romero, you got an email from you. You said that you, in preparing for tonight's meeting, you have a following regulation, 17623, which says immediately below B2 regulation, here is a C regulation, second sentence, it prohibits the flipping of a pre-existing basement which was non-conforming, whether finished or not. We maintain this as unfinished and as shown in municipal official documents, assessor tax file and realtor listing. Okay. Next one we received is a email from Paula Andros. Is she here? Paul Andros? No, okay. I'll read it. Dear members of the Philipstown Zoning Board of Appeals, I was dismayed to read the negative comments in both local papers directed towards your work. I've attended several meetings and watched other meetings on YouTube. You truly serve our community. At the November meeting, you agreed unanimously that the 529 Route 9D permit should not have been issued, that you allowed both sides to prepare and present at the January meeting. You respectfully heard all sides and invited anyone to add thoughts. When the presentation still did not provide a clear understanding of the situation, you determined that a site visit was merited. This you did perform with appropriate follow-up. You're doing fine work. I am sorry that there are those who do not see this. As a resident of Philipstown, I am concerned that the Route 90 plans do not come before the board before the permit was issued. My neighbors in Garrison are building a pool. They submitted plans and invited all neighbors to review them. The board reviewed the plans and issued the permit. The process was done legally. How could it happen and a building went up without this process? Is this happening in other locations? What purpose does zoning rules serve if the town ignores them? The Route 90 issue has caused stress and expense to both parties. It is a sad situation, and I fear it may result in expense to the taxpayers as well. I know you will use fairness and wise interpretation of the law in this case, but I simply wish it had never gone this far. You most likely feel the same. Again, thank you for your hard work. It's Paul Andros of Garrison. I couldn't have said it better. Next one is a letter I received from last Thursday, I guess the 27th. The town attorney, Stephen Gather. In order for me to read this, I have to, when the email says that it's a privileged communication and cannot be made public unless the ZBA board votes as a body to waive the privilege and provide copies to third parties. So,
I'll make that motion. I think the people deserve to hear it.
in a second?
Second.
All in favor?
Aye.
Yes, unanimously. That gives me permission now to read the letter. Dear Chairman and board members, I'm writing you as the town attorney for the town of Philipstown. The above reference appeal has come to the attention of the town board, and I have been asked to write to you in regard to it. The town board does not ordinarily provide any input on appeals, and in fact, the town board has no interest in the substantive issues in this appeal. But an issue has arisen in regard to the jurisdiction of the ZBA to hear and decide the appeal, which may have far-reaching effects on other zoning appeals in the town. And the town board wishes to make certain you are aware of the applicable law. The ZBA is chiefly an appellate board. In regards to appeals, its jurisdiction to hear and decide a matter is subject to an appeal being timely taken to the ZBA. If an appeal is not timely taken, a ZBA lacks jurisdiction. It cannot hear and decide the matter. Under Town of Philipstown Code 17559, a property owner who is aggrieved by the decision of the building inspector must appeal to the ZBA within 60 days of the building inspector's determination. If the aggrieved property owner fails to timely appeal, the building inspector decision stands. The ZBA must reject the application of a property owner to appeal from a building inspector's decision, which is submitted more than 60 days after the decision was rendered, because the ZBA lacks jurisdiction over the appeal due to the lack of a timely appeal. Under New York State law, the time limit for a neighboring property owner to appeal from a building inspector's decision is measured slightly differently. Recognizing that a neighbor owner generally will not be aware that a building permit was issued until work begins under it, New York courts established a rule under which a neighboring property's owner's time to appeal to the ZBA from the grant of a building permit is 60 days from the date of which the work was visible on the property or the neighboring owner actually found out the building permit was issued. However, in shorter, and he gives me a couple of different cases, so on and so forth. Page 2. In the above referenced matter, the town's building inspector issued a building permit to the property owner on November 11th, 2018. The neighboring owner, Jose Romero, filed an appeal from the building permit to the ZBA on October 10th, 2019, some 11 months later. The ZBA has jurisdiction to hear the appeal only if Romero's trust appeal was filed within 60 days after construction began. It's my understanding that construction under the building permit began in July of 2019, which would mean that the 60-day period expired in September. Further, in court papers served on the town, the Romero Trust acknowledged that it knew the construction was ongoing as of July 24th. Since Romero's trust failed to appeal 60 days after the construction began, its appeal is untimely and the ZBA lacks jurisdiction to hear it. I have heard that there were some suggestions that the Romero Trust actually submitted its appeal earlier than October 10th, 2019. If this is true, it would be relevant only if the appeal was submitted within the 60-day time limit. That means before September 24th. And yours was filed October 10th, I believe. Further, such a claim would need to be supported by a credible testimony from the person who delivered the appeal to the town. If no such proof is submitted to the ZBA, the appeal must be dismissed. I've also heard that there are some suggestions that the Romero Trust requested to see the building permit and the building department did not properly provide a copy of information to them. This, too, even if true, is irrelevant. A party who wishes to view municipal records is required to file a FOIL request with the town clerk, whereupon he or she will be provided with them. A party who directly approaches the building department cannot complain that his or her informal request was not honored. Perhaps equally important, I note that Romero Trust appeal to the ZBA was prepared and dated on an application dated August 12, 2019, over a month before the deadline for filing with the town. Thus, even if the building department's alleged failure to provide information somewhat delayed Romero Trust from reviewing the building permit, which again, I have no legal complaint over, it seems clear that Romero Trust had information necessary to appeal long before the filing deadline passed. Therefore, to suggesting that the building department did not properly provide information to Romero Trust does not provide any basis for finding the appeal to be timely. I'm sure you could appreciate the need for the ZBA, like all municipal boards and bodies, to comply with the law in regards to limitations of its jurisdiction. Let's see. I'm going to give you a copy of that, Mr. Romero, since you're the applicant, or your attorney, or wherever you want. Okay, I'll give you a minute to look over it. But I just have,
May I address?
well, second, I just have some questions for you, then I'll let you address it. I just want to clear up a couple things on the letter. I understand, the letter itself, but you have the letter in front of you, Mr. Rod? I'll give you a copy then. Yeah. I just want to address some issues to it. In paragraph 3, it says, under Town of Philipstown Code 17559, a property owner who is aggrieved by the decision of the building inspector must appeal to the ZBA within 60 days of the building inspector's determination. Now, it says here the building inspector made a determination. Can you tell me what that determination is and when the building inspector made that determination? That's paragraph 3.
This is when the permit is issued. You have 60 days from
November?
from the date of the permit under the code to file an appeal.
Okay, then I guess the wording is, then how would the owner know that they were aggrieved? I mean, or how would a person know they were aggrieved if
When the clock started.
they weren't notified?
Well, that's addressed in the, again, this is a letter from the town attorney. It's addressed
Yeah.
in the next paragraph. The common law rule is that if an owner has actual or constructive notice of a permit, such as seeing construction, the 60-day period would be told from the time that they knew or saw that there was construction.
Okay. Paragraph.
And just the gloss of that, by constructive notice, that means when someone could have observed it. In other words, if a neighbor is in Europe for 3 years, but construction has started, as long as it was visible, the 60-day clock runs from when it was visible, not, gee, I only saw it when I saw it.
Okay. Page 2, if you would go to page 2, paragraph 8, I think it's paragraph 8. It says, aggrieved property owner had visible signs of construction in July when he was advised was he advised to file a FOIL request from the town clerk? I guess the question in here, it says that it's necessary to file a FOIL with the town clerk. And I called the town clerk's office today, and they said the procedure for that is that you file the FOIL with them, and they forward it to, it would be like the building department, Mr. Greger, and then he would approve or deny it, and then, you know, he would supply building plans, whatever whatever the person asked for that file. So I guess my question, Mr. Mayor, when you made how many trips? 4 trips to the building department? 4 trips. At any point in time, did anyone advise you that you were supposed to go to the town clerk to file a FOIL?
No, not at all, and
Okay, all right, I'll give a chance, I'm just trying to get this straight in my head, okay? In the last paragraph, it says, will the ZBA be notified inspectors' termination? What I'm trying to do is trying to avoid this ever happening again, because this has been a great expense to all parties involved here, and a great deal of time and effort from everybody, including the board. So I'd like this never, ever to happen again. So how do we do that? I guess what I mean by that is, like Mr. Romero didn't know that there was a true violation. I didn't know that there was an issue. The only way he could know that would be viewing the building plans. So if he didn't build a building, you know, in the building, when he looked at the building plans, then he realized that it was bigger than, in his opinion, bigger than 25%. That was one of his concerns. So I guess what I'm trying to say is, how could we stop this not happening next week? The same thing. You have any suggestions?
Well, I think the letter, if you have questions about the letter, you want to consider the letter longer, that, again, they have an appeal to this permit, and they've made arguments as to why it was incorrectly issued. The parties that have constructed the building take the position that it was not, the permit was not incorrectly issued, it was correctly issued. And with respect to the timeliness issue, the letter from the town attorney, which I've read, just sets forth the law that governs how the board is to address those issues.
Okay. In the paragraph, it says that the applicant has to file a FOIL with the town clerk. So what I did was I got copies of what we send out to neighbors, to residents surrounding on appeals. Like, you know, when we have an appeal and we send out the letters to the neighbor. And I got a copy here for you. If you want to just take a look at it, please. And basically what it says on page, first we send a legal notice that's going to be a hearing and so on and so forth. Then on page 2 it says that notice is hereby given to be a public hearing and so forth. And the last paragraph it says that at said hearing, all persons will have the right to be heard. Copies of the application, plat mat, and other related materials may be seen in the office of the building department, 2 Cedar Street, Cold Spring. Now, as far as the years I've been on, Mr. Stone, you've been on the board a lot longer than I have. I've always told people that the files are accessible to them at the building department. I never told them to file that they had to file a FOIL request with the town clerk. So,
I never did.
huh?
I never.
Did you ever?
I never told them. They would just walk in and they would ask for it and they would be handed to them.
How many years you been on the board?
25 years.
25 years. So what I'm trying to say is that I think we should correct this. So maybe if the town, our clerk would work with you, so we could have, because we're putting a legal notice in the newspaper, then we're not we tell them to go to the town, to the building department. So if I got that, I would look at it and say, well, I'll go to the building department and get copies. And I go to the building department, only to be told that, no, you can't do that. You have to go to the town clerk first and file a FOIL. I think it's kind of misinformation. So I think we should correct that. Do you agree, or?
Well, I mean, we're here to decide this particular
Well, I'm asking you, could you
appeal.
work with our secretary on this, to change this?
to change.
Make it correct. Legally correct.
Okay, but we're talking about this appeal and the timeliness and the merits of
I understand
this
that.
appeal.
And what I'm trying to do is.
I mean, I'm just saying as counsel for the board on this appeal,
Right.
in terms of, you're asking a question about implementing changes in policies.
I'm not changing, I'm just trying to correct it. The misinformation that were given to the residents. That's all I'm asking. Well, we could do that another time. Could you put that, could you put that on for next meeting? Please, with that, we'll discuss this, that this has to be corrected, because we're giving people false information. Okay, thank you. And at this time, Mr. Mayor, I guess you could speak, because the board, hands are tied. The town board has made a decision that, to ask the attorney to send a letter to us that we can't continue hearing this or make a decision. So, you want to talk about it? Sure.
Good evening, Luke Hilpert on behalf of the Jose Romeo Trust. I don't think that, as the town board said, this is an advisory letter. They cannot bind your hands here. They've asked the attorney to provide you with his interpretation of the law. But I don't believe, as you just said, that they can bind your hands in this instance. I'd like to just speak on a couple things relevant to this, and if you want to hear more later, we can go back to that. But at the building department, there is a folder on the wall for FOIL forms. If you go in, you ask there, they have the forms there, they process them there, and they'll give you the file there. Now that procedure may have changed. For years, as Mr. Sestone said, you could go in and ask for it. And they've been requesting the forms more and more recently. But it is. But it is.
Letter said it had to go to the
I
town
understand.
first.
I'm just saying it's not. That may be the procedure that
don't know. We're
that
trying
they
to
have
find
on the
out.
books, but the way it has been done and the way it is done is there is a little plastic thing on the wall that has the forms in there. That you can receive the forms, hand them in there, and they'll generally requisition the file if it's during a certain time period. So we're here talking about the timing again, and really, this permit was issued, but it wasn't clear what the basis for the permit was when the construction began. There was construction going on. We didn't know why the construction was going on. We didn't have a proper interpretation of it. It wasn't until we continued to contend that it wasn't until we received the plans that we understood what the building inspector's interpretation was. It was at that meeting, when I met with Mr. Warner, that he provided us with his interpretation of why that building permit was issued. And that was at that August 12th meeting, 12th, 14th, whatever the date is. And it was his understanding was that you could unfinish a basement, and we can talk later whether that was finished or not, but you can unfinish a basement and that space would be flipped and added to the addition on the second floor.
At this point in time, okay? Because I'm reading this letter, and like I said, this is from the town attorney.
Understood.
So, and the town board asked him to write this letter
Yes.
to us, okay? And the last paragraph says, I'm sure you can appreciate the need for the ZBA, like all other municipal boards and bodies, to comply with the law in regard to limitations of its jurisdiction. But basically, they're telling the town boards, they're telling us we don't have any jurisdiction to hear this. So, I don't want to break the law. That's the last thing I want to do. Okay, so at this point in time, I'm going to have to, I think it's up to the board. Do you want any comments? I don't think we could even hear this.
Well,
I think we have to render a decision that they were untimely, and let the court sort it out.
Well, it says we can't make a decision here. It says, I'll read it to you again.
Well, just to.
It says, wait a minute, let's go by the letter that I received from the town board attorney. It says, we lack to jurisdiction, cannot hear or decide the matter. I'm not going to violate the letter of the attorney's letter.
Just if I could interject, Mr. D, there is an appeal from the building permit. The board, there are two issues. Number one, the issue of timeliness, based upon the criteria set forth in the letter. The board, if it finds that the appeal was not made timely in accordance with the law, the board would need to make that determination.
What if it doesn't determine that?
Excuse me?
What if it doesn't find that what if it doesn't have that finding? What if it doesn't agree? What if it finds differently?
If the board finds that it was timely, if the board decides that it was timely, it can then consider the merits of the application.
Okay.
The
Yeah, I understand.
There are two issues. Number one, was there a timely appeal? You have correspondence from the town attorney, and there have been arguments on both sides. If the board decides that it's not timely, it need not go any further. However, if it does find that it's timely, it would need to address the merits of the appeal.
Well, like I say, the letter from the town attorney, it says he's writing to us from, the town board asked him to write to us. So in there, it says, that we lack jurisdiction and cannot hear and decide the matter. So I'm going with that.
I'm saying that would be the determination for the board to vote on. In other words, there's an appeal, there has to be a decision on the appeal. The appeal could be decided, I'm not telling you how to decide it, the appeal could be decided if the board so chooses to say, we find, based upon our understanding of the law, that the appeal does not comply with the timeliness aspects of an appeal, and that would resolve the appeal.
Right here, it says we lack the jurisdiction to hear or decide. So I'm going to go along with, I have to go
But
along with the
I'm just
attorney.
saying that has to be in the context of a decision. In other words, the board can decide and should decide if it so finds that the appeal is not timely, that it doesn't have jurisdiction and to
Doesn't say
deny
that
the
here.
appeal.
It says we should dismiss it, not that we should find that it was untimely.
That's correct.
Mr. D, could I just make a...
I'll give you 1 minute, that's it. I'm not going to hear all kinds of people here. I'll hear you, and then I'll hear the attorney, and that's it.
Basically, what I'm here to say, and based on the video that I saw last night, was to talk about the timeliness of this appeal and the accessibility to the file. Now, when I happened to be at the building department for another meeting with Richard Shea and Nancy Montgomery on the Garrison Hamlet Association issue that we had there, I was there when the applicants were addressing the building inspector to get access to the files. He was uncooperative. I was waiting and you know how small that office is, so I can obviously see that he did not cooperate. But I went on to my meeting. I called Hossein later and said, what happened? He said he was denied. He was denied an application for an interpretation. So as to the timeliness, I think my witness to that meeting is heavy in this case. It has weight. Now, as to accessibility of the file, I also want to say that it's not an isolated case. I have been to that building department twice to get files on 8 Alfalfa Lane and was denied access once. Mr. Goldsmith, who is a neighbor of 8 Alfalfa Lane, went there, was told that the files were at the health department. We were told when I went there with another woman, Barbara Turney by name, that he was examining the files. They were open and on his desk, and he could not show them at that point. So to underline your point, Ms. Clare, that we were denied accessibility. And as to forming a FOIL report, it is my experience on the zoning board, as long as yours has been, that you went into the building department, you filed your name and what file you wanted to see. That was what you did. This undermining of the appellate function of the ZBA by the town attorney is absolutely outrageous. You do not need to dismiss this case on any, you may go ahead and hear it. Thank you.
Thank you. I said I would give Mr. Smith a chance to talk. And then you'll finish up. Okay, Mr. Smith.
Good evening, Mr. Chairman, members of the board. Frank J. Smith III, attorney from the law office of William A. Schilling Jr. on behalf of interested party respondent, Hill and Valley Properties, LLC. I'm pleased to hear the opinion of the town attorney this evening and
From the town board.
the memorandum advisory opinion of the town attorney.
Correct.
The relief that we have requested from our initial submission to this board is for the board to dismiss due to untimeliness. I would like to just reiterate that this evening, and that is the relief that we are seeking. This board can dismiss the appeal due to untimeliness, and that would be the decision being rendered, and that is the decision that I respectfully request this board make this evening. And I thank you for your consideration.
Thank you. Mr. Hilbert?
Yes, I would just, if the board is going to, as Mr. Rod said, you are going to render an opinion, I'm sorry, you are going to vote whether to dismiss this or not, if that,
I'm going to vote without an or. Go ahead.
well, but it says if you have to vote, I would just ask that, on behalf of the applicant, I'd be entitled to respond to that letter and
You
give him the
respond
time
now to
to.
it? Oh, you mean
Well,
you told him right,
he
you
has,
talked about-
he has specific cases in there that he's cited,
Okay,
and I would
right.
like to, as, you know,
Okay.
as I think is fit, if this board is open to voting on it, then I think we should be given that opportunity to
Right,
to
well,
respond there. And I
First
would
of
just
all,
request that.
right, we don't have the, unfortunately, not unfortunately, Mr. Lim's not here tonight because his daughter-in-law went to the hospital to have a baby, so that's good news
That's
anyway.
good
That's
news.
one good point here. So we couldn't decide on it anyway, but the way I read the letter, I'm not a lawyer. I'm just a regular guy, okay? So I have to go by the lawyer. He's the lawyer for the town, okay? And they had the town board, who we serve at the pleasure of the town board. I mean, even though this is voluntary, they could, get rid of us anytime they want. And he's telling us that we lack jurisdiction, we cannot hear or decide the matter. So I don't see how I could possibly hear it or decide it.
Plus, he can prove that.
Well,
And he said, but in his last sentence is, I'm sure you appreciate the need for the ZBA, like all other municipal boards and bodies, to comply with the law in regard to limitations of jurisdictions. I have no intentions of breaking the law.
No, of course, but I think what I was trying to point out is that Mr. Rod had said that you will be, even though you said you can't vote on this, you will have to vote whether to dismiss it or not. And I would just like the opportunity to be able to respond to this letter in order to address the cases he has. As, you know, my previous letter, I did bring up some cases that stated
Okay.
that, you know, waiting is something that is
understand.
done when all the information. So I would just like the opportunity to be able to do that
Right.
and before the board takes that action.
I'm in a conundrum at this point, okay? I'll be honest with you with this letter, okay? Of course, I want to follow what the town board advises, for the attorney. I don't know, so what do I do? I don't know what to do. I'll be honest with you at this point in time. The board has to decide. Like I said, there's not a person, the fourth person's not here tonight, so I guess the only thing to do is to hold this over to next month, which I really don't want to do because I know how much time and expenses everybody has put into this. But I don't see how three members of the board here could just all of a sudden decide on this if we can't decide on it. I mean, I'm speaking to the letter. The letter says you cannot hear or decide.
Well, right, I think you do need to decide, and as you
Right.
pointed out, you do
We-
have the appellate
we have
function. You are,
quorum. We could decide, but it'd have to be unanimous.
Decide on what?
Decide to dismiss, because we have a quorum.
Oh, I see. Decide to dismiss be unanimous. Okay. All right. He's saying that,
But I'm interested to see, if you can prove that you were timely, I'd be willing to hear it, personally.
right, and then I think.
But you'd have to be, you'd have to have it nailed,
I understand that.
because your opposition is in the right based on what was said.
I absolutely understand what that letter says and what Mr. Gaba is stating, but I would like to be given the opportunity to provide our rebuttal to that. It is certainly, he is the town attorney, and he is to advise the town, but it is certainly his interpretation of the law, and if there is a different interpretation that is available, I would like to be able to provide that.
okay. Okay, once Mr. Turner. Mr. Smith and then Mr. Turner, that's it.
Respectfully, Mr. Chairman, I have yet to see the letter from the town attorney.
Oh, sure, I can go
Would
ahead.
you mind stating for the record the cases, just the case names that he cited?
I'll give you a copy of the letter. Hold on. I have an extra one. You're an attorney involved in it. We got an extra copy. Hold on.
I have a copy.
You have a copy to give him? All right. Here, next one. Here's a copy for you. That's okay. we're not trying to hide anything here, okay? You know, I'm just going by the letter I have, and I have to deal with it.
No, and the reason why I wanted to ask, Mr. Chairman, is that this memo cites Clark versus Town of Sand Lake Zoning Board of Appeals.
Which I know nothing about.
Respectfully, Mr. Chairman, that case was provided to you in my submission in December of last year. So, with all due respect, I think the time to address the matters of law that I have raised for the past however many months has come and passed. I've submitted all of these cases to you, all for your review. It took place in December of last year, after we were here the first time in November. So I have not been presented a contrary canon of law, a case, anything that would dispel the requirement of the 60-day filing of the appeal. So I would respectfully ask that this board close the public hearing and render a decision. Thank you.
Ms. Turner, and then,
On another matter,
let's come to the microphone, please.
the Garrison Hamlet Association was dealing with 1122, which is the gas station on Route 9D. And in my notes and my presentation at that meeting, I would like to read you something that I presented to the planning board, which is relevant tonight. And as to having a witness to the inability to get a timely appeal filed because you don't have access to things, I think I, as a credible witness, should bear weight in your decision. But to reinforce what the Zoning Board of Appeals has, and I will read this, the Court of Appeals has upheld that a Zoning Board of Appeal performs a quasi-judicial function when it renders an interpretation of a zoning provision, and as such should act according to its own precedents. In numerous cases, the court has reinforced the principle that a Board of Appeals is the sole interpreter of the ordinance, not the town attorney. You are the appellate body in the code, not the town, not the planning board. You are the appellate, the one that makes the judicial spirit. You act as a quasi-judicial body. And therefore, do not dismiss this case based on Mr. Gaba's interpretation of the law.
Thank you. Mr. Romero, Doctor? I'm Dr. Romero, I'm sorry.
You know, there's been a lot of legal talk, and I'm talking as a citizen. I'm just a physician. But I certainly did not have constructive knowledge of what was going on until August the 12th. From August the 12th to October the 10th, if you want to get technical about it, it's 58 days. I was denied a faithful copy of the plans. How could I make an appeal? And I was denied the paperwork for making an appeal 4 times. I believe the 5th time, in front of my lawyer, I asked the inspector a list of questions that I can give to you. He refused to answer any of them. How could I file something if I don't get the information or the paperwork to file? If I don't have the plans to look at, and even if I looked at them, I mean, they're hieroglyphs to me. It has to be looked at very carefully to see exactly what is going on. From August 12th to October 10th is within 60 days.
Right. Well, it's my understanding, one question, I just want to ask you one question. I'm trying to get all this straight in my head. When you originally went to the building department, I guess it was, your thought was, you weren't sure if there was anything wrong. You just wanted to see the plans to see if it was more than 25%. Am I saying that correctly?
Well, I just wanted to know what was going on.
Right.
Because, you know, there's a big construction.
Right.
And by the way, you know, this is not an extension or an expansion.
Right.
When you calculate the area, the living space of the new structure, the old structure was 1196 square feet. Now this adds up to 33,499 plus an impermeable porch of at least 500 square feet. We're talking about 4,000. The old cottage had 1196.
Okay.
It is This is not an expansion. This is a completely new house. There's what's left of the old house? The foundations. It is a three-story structure plus a living porch, heated basement, finished basement.
Right.
This was an unfinished basement. There was a finished basement that was unfinished. It was flipped upstairs, not as a basement, as living area. But the total area is over 3 times, nearly 4 times the original living space.
Well, there's two sections here, that we're looking at, okay? The first one is the timeliness, okay, the 60-day thing,
Yeah.
okay? And the second would be,
Right.
is it over 25% or
Right.
so on and so
And-
forth?
and the
So
other-
it's two
Yes.
different, to combine, but I'm trying to say we
Yes,
each is handled
yes.
separately. So your point is, I guess what you're trying to say is that you wouldn't be able to know anything until you saw the
That's correct.
plans, and you didn't get to see the building plans till August 12th.
Because they denied us
Well,
4
yeah.
times to file a petition.
Right,
And in fact,
okay.
there's multiple emails to the inspector.
And we have it.
And you have all of that.
We
It's
have all
not that, and I was begging, to please, why don't we get a third-party objective
Right.
group to look at this and see who's right. And the one last point, I can't see that the building permit was legally granted. The regulation specifically says, B2, you must, I mean, there's no equivocation about this. You must, if you're going to expand a non-conforming structure, you must ask for a permit of the board. That was not done.
Okay, thank you.
Mr. D?
Sure.
Mr. Smith, your project is not being delayed. You're not stopped working or anything like that, okay? I don't see a problem giving Mr. Romero's attorney a chance to prove that he was timely,
Okay,
other than we're going to lose time.
right. What you're saying is that it's not stopping the,
We're not stopping them from
Construction.
finishing the structure.
okay. But your opinion that we continue this till next month?
Yeah.
I
Ms. Claire?
agree. I think that we should look at the outstanding issues and
All right.
make a decision.
I was looking, sure.
Mr. Chairman.
Go ahead, well, let's see, one at a time, relax, calm down, everybody get a chance to talk.
I just want to say, I'm sorry, it's guess my zoning
No,
experience
listen, I
is
just want
coming to the
this is
fore.
here that everybody
But
can speak. Go ahead.
also, provided for all of us when I was the zoning board, the New York State Department of State on zoning is clear with the case law about the appellate responsibility of the Zoning Board of Appeals. You can refer to that in your deliberations before next month to see that you do have that right. And perhaps in some ways you might ask Mr. Galba to refer to it also, since I think his interpretation is notwithstanding, is in contrast or contrary to the New York State Department of State case laws that is on they have manuals
Right.
on all of this. So I just wanted to make that suggestion that you could seek outside advice other than the town attorneys. Thank you again for your patience.
Who outside advice would I
I mean,
speak to?
outside, I'm saying outside, New York State Department of State is a
Department of State.
huge thing. Another outside attorney that you might know, ask.
I mean, I'm not going to pay for an outside attorney, okay? But thank you, but you understand my predicament here.
Oh,
with this.
absolutely. I mean, you're between a
placed on
rock and a
spot
hard place. In fact, the zoning board is always between a rock and a hard place. It's one of the most difficult functions to carry out. And anyway,
Thank you very
just
much.
wanted
I
to point
appreciate
out.
your- I appreciate
Thank
your
you.
input. All right, I'm going to give you the last shot.
Respectfully, Mr. Chairman, I disagree that you're between a rock and a hard place. The law is clear. The law is absolutely unequivocally clear, and there have been no facts presented to this date that would change the law. What's being asked of you this evening is to disregard the long-standing case law on this particular subject, of which you and this board has been provided with for months on end. There is absolutely nothing here this evening that has changed from when we first came here in November of last year. You are being asked to disregard the law, and I think that's highly inappropriate. The case law is very, very clear. It's a 60-day requirement upon actual notice. And I would just like to state, again, we can move the goalposts here again this evening and kick the can another month, but we can go back and we can go on YouTube and we can watch all of our previous appearances here, and we can see on the record the applicant stating that they knew construction took place on July 12th, 2019. That is the date in which the 60-day timeline should be based off of. And as I've mentioned in previous presentations, that even if the interested party respondent were to concede the later July date, it still would have been untimely. So I'm asking you this evening to respect the law, to close the public hearing. If you'd like to wait for the next meeting to render a decision, I'm sure you could seek the advice of counsel to do so. But I believe the public hearing should be closed because, as the town attorney has advised, this board has no jurisdiction to hear anything further. The opportunity has come and gone. We met here in November. There was no meeting in December. We met in January. We were here in February, and we're here again in March. And there is nothing that has changed to weigh in the contrary to the position that I have advanced on behalf of the interested party respondent, and I respectfully request that the public hearing be closed. Thank you.
Thank you. Anybody else? Yes, sir. Dr. Romero.
There are two lawyers for the town. On November 18th, Mr. Rod advised the board not to take a vote because we were petitioning the court. By the way, we petitioned the court back in August because we were getting absolutely no cooperation from the buildings department, no ability to petition anything. So we asked the court to intervene. November 18th, you were stopped from taking a vote because there was a court hearing the following day. In court, the lawyer, who I believe, Mr. Rod, is your partner, in court, is he? The lawyer in the court is your partner?
I'm not sure which attorney appeared in court on that day.
Well, he is your partner.
I'm not a witness. What's your point?
Okay, so I won't ask you any question. But Mr. Gaba is your partner.
Mr. Gaba is my partner.
So, here we are ping-ponged from the ZBA to the court. The following day, we go to court, and the lawyer, presumably of the same law office, says, oh, no, you can't do that because that belongs in the ZBA. That is the reason for delays. And now, today, we have Mr. Gaba with a last-minute letter saying that actually you cannot do any of this. We have 3 lawyers for the town actually thwarting our efforts. I think that that is wrong and causing all of these delays from November 18th, 19th, January 10th, February 10th, and today. The 3 lawyers essentially have prevented this case from going forward. November 18th, you were ready to vote. And Mr. Rod prevented you from voting, saying, no, you have to wait for the court. We go to court, and then the lawyer there, presumably, he won't answer. His partner says, no, you have to go back to the CBA. Now knowing that there was a delay till January. And now in March, we hear the same thing. I think you have heard opinions that this is a lawyer's opinion, interpretation of what you should do.
Okay, but you understand the
I
position
understand
the board
your
is
quandary.
in.
No, I understand your
Okay,
dilemma.
the town board has asked the attorney to write us this letter. Okay, in this letter, it says here that we cannot hear or decide the matter.
I realize that.
Otherwise, we're breaking the law. So,
Well,
it puts me in the spot. I know he's saying it's not in the spot,
No,
but he is in the spot.
I don't think that they are the final word in
Right.
terms of your.
Well, that's probably what we're
In
going to have to
terms of
seek
the
for the
law.
next month. We might have to seek
It
that.
may be that an uninterested third party. This is an interested third party, second party. They're defending the town from possible repercussions of this case. I want you to take that into consideration.
Thank you very much. I guess we got two choices here. Two choices to make a decision. Well, we can't. I'm not going to make a decision. It says not get to sell. I'm not making a decision. It says here I can't make a decision.
Well,
Do you want? Go ahead.
Yeah, just to be clear, the board needs to act on the appeal. It's your call. You don't have to vote tonight because Mr. Lim is not here. You could decide to vote tonight. The attorney for the appellant asked for the opportunity to reply to the town attorney's letter. So,
Mr. Rod, can we make a condition that at the next meeting, only the two attorneys can present the information related to the timeliness? Or is that not allowed?
you certainly could. You can close the public hearing with the exception of receipt of additional correspondence from the appellant's counsel, giving the attorney for the respondent the opportunity to reply, and that's it.
I'd rather not do that because I'd rather leave it open because Ms. Turner tonight, who's served on a board for years, has made some statements that she was there during the Dr. Romero was asking for the information and so forth. I think it's important that we hear her also. So I'd rather leave it open.
I'm okay with that.
I'm okay with that. So at this point in time, I guess the board decision is to
Continue until next month.
continue to next month. So this will be continuation until next month, April 13th. I don't like it any more than anybody else does. Thank you. Make a motion to adjourn?
Second.
All in favor?